This is Michael Popok. It's time for Legal AF After Dark. DC Court of Appeals ruled, as everybody knows, against Donald Trump, finding he has no absolute presidential immunity for criminal conduct while he was president. Of course he doesn't. We don't want that in a constitutional republic. But you don't come to Legal AF for just what happened. You want to know what happens next. We talk about what happens next on our Legal AF podcast. Confused? Want to know when the trial of the DC election interference case for Donald Trump is going to be? Is it going to be in March? Is it going to be in June? Is it going to happen before the November 5th election? Tune in. Let's kick it off with what sounds like old news, but it's really just fantastic news. Everybody was tapping their foot, waiting for the DC Court of Appeals to get around to ruling in a month, which, by the way, is lightning fast for any appellate court. I've been doing this for a long time. I've never had an appellate ruling in a month. If I get it in 6 months, I'm like, wow, that was fast. So we just wanted it fast because it had impact and impacted when Donald Trump would be tried. And the other trials sort of were waiting for this one to be set. But we got it. And we know now, after reading the 57 pages very carefully, we learned a lot of things. For me anyway, and I'm sure you too. We learned what the struggle was that we were waiting on between the three. We knew that they wanted to try to come up with a 3-0 vote, and they did. We can tell from the way it's written where Judge Henderson and her position about discretionary versus official conduct sort of drove a portion of the decision. We can see the jurisdictional discussion that was really led by Judge Childs. We see how that takes up 10 pages or so to just declare once and for all that they had jurisdiction about this interlocutory issue on appeal. And then we saw the heart of it, which I really think Judge Pan took the lead on, or her clerks took the lead on with her, about separation of powers, immunity, public policy, lack of due process, and the impeachment argument, all laying them all to waste in 57 pages in such an airtight package, as I said at the top of this podcast, that there's a chance, I want to talk about it with you and debate it with you a bit, there's a chance Supreme Court, led by Chief Justice Roberts, who sits over the DC Court of Appeals for administrative purposes, doesn't even take the appeal. And certainly I don't think there's any way in God's green earth that Donald Trump is going to be able to ask for an en banc, full 12-member DC Court of Appeals decision to delay this thing further. And we'll talk about that next. Let me just dive in. I'll frame it, turn it over to you for the rest. I'll focus on the parts that I liked about the decision. The attacks on all of Donald Trump's key arguments, I thought was masterful. And it's got to make the Supreme Court stand up and listen. They spoke their language. They do well at the DC Court of Appeals does well at managing up. They know that all of their decisions ultimately end up usually at the United States Supreme Court, especially about momentous ones like this, about the presidency and the role of the presidency. And it completely laid to waste any arguments and the fundamental misapprehension of Donald Trump's lawyers about the separation of powers, what it means in terms of Congress passing criminal law, the president having to abide by criminal law, and the Article 3 judges being able to determine whether the president complied with the legislative branch's criminal law. That is our co-equal branches of government. That is that they are supreme in their own sphere, but there is a checks and balance built into it. Not in the arguments that Donald Trump made. Donald Trump wanted to float above the entire constitutional structure and be above the law, literally. And he even said that, taking snippets from one sentence from Alexander Hamilton in a Federalist paper that he completely distorted out of view, and walking away and trying to walk away from all of the precedent that got us to this point. This is not the first time the presidency, a lawsuit, and/or criminal prosecution or process have been addressed by the court. There's a series of cases, including some with Donald Trump's own name on it, coming out of your old office, the Manhattan DA's office, Cy Vance versus Donald Trump, that upon which this is the next proper incremental step and link in the chain about it. Donald Trump tried to graft onto it the civil analysis, which is, well, you try to figure out the scope of my authority and my duties, and then on the outer boundaries, the outer perimeters. No, that's a civil analysis. The criminal analysis is if during your non-discretionary function, your conduct violates the criminal code, There's no absolute immunity to dismiss your indictment, plain and simple. It's breathtaking in its simplicity in the analysis because it comports with our system of government and the three co-equal branches of government, without which you have an unchecked, out of control leviathan of a presidency. And that is the heart of that analysis, that's baked in there. Then in a footnote, they completely got rid of, we keep talking on the podcast because Trump keeps talking about it in his filings about First Amendment right. I got a First Amendment right. I had a First Amendment right. And they said you have basically abandoned and waived your First Amendment issues because you didn't raise them up on appeal. So Judge Chutkan on First Amendment, finding no First Amendment to commit criminal conduct protection, is gone. Your due process arguments you've abandoned. And so whatever Judge Chutkan said on due process stands. So take those off the board. And then lastly, and I'll turn it to you, I want to hear your view on the impeachment decision. We thought that was always the weakest argument for Donald Trump, a misreading of the amendment that relates to impeachment, the impeachment clause, in which they argued that under all circumstances, the only way a president could ever be indicted in the criminal justice system is that he first has to be impeached and convicted in the Senate, and then he gets turned over to the criminal justice system, which was completely asinine and had no support in the literal text of the impeachment clause. Nowhere in there. In fact, the opposite. It said, the impeachment clause basically says the only thing that can happen through impeachment is removal, and indictment and prosecution and criminal process is left for the criminal justice system, but not to Donald Trump. Donald Trump argued, no, there's a negative inference. The negative inference means that because they didn't, there's like a comma there, that therefore he has to be convicted first, and since he was never convicted. And that's where the SEAL Team 6 great question that just shot John Sauer out of his chair at the oral argument came into play when he said, I don't get this. What if he ordered SEAL Team 6 to take out a political rival, Judge Pan asked. You're telling me he's got to go through an impeachment conviction process? And what if there's no time for an impeachment conviction process? Or what if the senators don't want to convict because they said he's out of office, and you took the position that don't worry about him being out of office, the criminal justice system will take care of him, which was an inconsistent position that was pointed out in the brief. I want to hear your view on the brief, and then I want to hear what you think, if anything, the United States Supreme Court does with this 57-page decision.
So look, when the decision came down and I read it, the first thing I thought of was, those like those New York Times or other newspaper headlines that are simple, like Obama wins presidency or something, just like 2 words, 3 words in big headlines. And for me, it was Trump is not immune. Like this was such a powerful decision, and it's so important. And in some ways, it is something that no one's ever ruled on before, whether a former president can be prosecuted criminally. That's never been ruled on before, or whether they have executive immunity or presidential immunity. And so this was a momentous decision. And for them to find in such categorically 100% unanimous terms, so this was they call it a per curiam decision, which means it's not written by any one judge. Most of the time, decisions are written by a judge, and you know who it is because their name is up at the top, and it'll say this is a decision by so-and-so. And then you'll have sometimes dissents or concurring opinions by other judges, and they name who it is. But this was a per curiam decision, which means it was unanimous. So again, you have judges on both sides of the aisle who have different thoughts, concerns, opinions, and yet they all came together and unanimously wrote this decision. So I thought that was really incredible. The decision was just beautifully written, and it was both a history lesson, a law class, and it was not the other thing I really love about it too is when parties are advocating a position, they're advocates, right? And they give their position and they make arguments in favor of their position. Trump sometimes takes it to absurd levels. Sometimes his lawyers rein it in, but he takes his to absurd levels that make no sense. But sometimes he makes arguments that make you concerned, right? And a little bit, at least me, a little bit worried. What will happen and what could happen, and how will this play out? And what's beautiful about this decision, and really most Court of Appeals decisions in particular, is judges rise above the partisanship. They rise above the bickering. They rise above the pot shots or the, clearly gratuitous comments. Trump always starts everything he writes. It's clear his lawyers. He tells his lawyers, Donald Trump was President Donald Trump, the 45th president of the United States of America, and the current leading candidate and presumptive nominee of the Republican Party. It's so clear that he's trying to either intimidate or color the arguments in some way and put a gravity to them that he thinks will either intimidate or sway the judges, I think. But this court in particular, their writing is incredible. And they surgically dealt with every single argument in one way or another, and really just gave a masterclass in the law. And they did it in a way that I think they know that the audience is going to be broad. Many times, the only people who read court decisions are lawyers. And so many court decisions are written in legalese with a lot of Latin words and phrases and things that you might not understand. Well, this was beautifully written and approachable and understandable at the same time. And so it really is a great decision, not just because it ultimately ruled in favor of what I think is common sense and what should be the law, but also in a way that I think it's going to be hard for the Supreme Court to do anything but uphold everything that they said. I mean, I don't see any weakness in any of their arguments. And the thing that they also did that I thought was great is this Supreme Court that has a super majority of Republicans, frankly, they have most of their decisions, that things like when they overturned Roe versus Wade, et cetera, they like to go back to the old timey days and really look at history and look at what did the framers intend and mean when they did certain things. And even to the point where when they were defining terminology, sometimes courts, when there's no, and this is common, when there's no definition of a particular word that's in a statute, sometimes what they do is they look to the dictionary definition, right? They even went back and utilized the dictionary from the year that either the amendment to the Constitution or the article that they're referring to. So it was either 1700s or early 1800s. They even used the dictionary with the definition of the word from that time. I mean, that's how careful they were to try and come up with what was the true legislative intent behind all of these concepts and what the law means. And so I thought that this particular, that's what, when you said your question of what was your favorite, that's my favorite, is just, this is kind of a bulletproof decision, I think. It's so good that the Supreme Court could even just deny cert and say, we're not going to even hear the arguments because this is just a perfect decision, and just go on with the trial. But if they do hear it, it'll be interesting to see if they give any insight into which of these issues they think that they would like to hear. And the court started out with an issue that the parties didn't even really raise or argue, but that the amicus briefs, the amici, the friends of the court who submitted briefs, they're the ones who raised, which was, does the court even have jurisdiction to hear this presidential immunity matter? Do they even have that ability to do it midstream the way they did it, or which is what we've called an interlocutory appeal, because usually you have to wait until after a conviction to appeal. And so they addressed that first because that was sort of foundational, right? Are we allowed to even rule? And that was a foundational question that they addressed. And there was a case that we've talked about, and and other lawyers have talked about Midland asphalt, that was throwing a little bit of a wrench into whether or not this was appealable midstream at this level. And they really handled the issue and said, absolutely, that we do have jurisdiction, and we are going to exercise that jurisdiction. And so, yes, this is appealable midstream. It's appropriate for an interlocutory appeal. They also went through the separation of powers, which is fundamental to our democracy, right? When the framers of the Constitution were fleeing the rule of the king and England, et cetera, and they really went through and talked about what it means, and how Marbury versus Madison, which is an old case that we all learned about in law school, and talks about how the separation of powers. And I thought what their analysis there, what was really just spot on, when they were talking about the famous phrase that everybody talks about and always cites, which is nobody's above the law, right? That came from a case, United States versus Lee in 1882, and really emphasized that principle, and that the President of the United States is being prosecuted because he violated the laws that Congress passed. So they were very clear to talk, and what you were just talking about, which is this whole concept of discretionary versus ministerial decisions. Those are two words that the courts have been fighting over and arguing about. And what does that mean in the context of immunity? And I'll be honest with you, Popok, that was a concept that I really struggled with understanding until this decision. I didn't understand when they kept talking about discretionary decisions versus ministerial decisions. And if it's discretionary, the courts can't review it. But if it's ministerial, they could. Until they explained it in this, I really finally understand it in a way that it not only makes sense, of course, that's the law, and to just to think about it in a way that everyone can understand it, is if Congress passes a law and basically says, this is what the law is, whatever it is, and therefore, as an executive, as the president, he's obligated to actually implement that law, right? That's his job. His job is to create agencies to implement the very laws that Congress passes. If, however, he does, and that's what they called ministerial. And I guess maybe it's the words that I just thought, because that doesn't sound ministerial to me, but that's what they're calling ministerial. And then discretionary were things that are important to him, things that he wants to do, or she, if you're whoever the president is, right? Things that are political, right? Things that you're going to emphasize, that you're going to focus on, right? I care about global warming, so I'm going to give people money to recycle or something, things like that are discretionary, that those are things that are political. And what they said was it's entirely appropriate for the electorate to, if you don't like what he does politically, in other words, if you don't like his philosophies and the things that he emphasizes, then don't vote for him. That's the remedy. But the president has the duty to take care that the laws are faithfully executed. That's actually in his job description. It's the take care clause of the Constitution. And so when Congress passes a law, he has to take care that those laws are faithfully executed. Trump wants to be immune for any actions that he does there. And what they specifically says was, if he violates the law, he's violating the laws that Congress passed. And therefore, he's not taking care of the laws, and he is not doing his job, and therefore he can be prosecuted federally. They made that very clear too. So that was the part that I thought was most powerful.
One of my favorite ways that they cut Donald Trump literally down to size is that they paraphrased Chief Justice Marshall, who on the scale of the greatest Chief Justices, he's at the top, he's number one. If it wasn't for Chief Justice Marshall and the Marbury decision in 1807, we wouldn't have a Supreme Court doing checks and balances over over the presidency or over Congress. He kind of gave them their job description in his famous case of Marbury versus Madison, which is the case that Donald Trump's lawyers fundamentally misapprehended, as you've outlined, Karen. But in a case involving Aaron Burr, the person who assassinated Alexander Hamilton, Marshall put it this way, and I'm paraphrasing, but just a bit. Presidents come from the masses, they come out of the mass of the public. And when their term is over, they return to the masses. And they called Donald Trump here not President Trump, they called him Citizen Trump, who has no more rights or defenses than any other criminal defendant has. They said that early on in the case. That stands in stark contrast to every time Donald Trump's lawyers, as Karen, you alluded to, every time Donald Trump's lawyers file something in federal court or any court, they start with, Donald Trump got more votes than anybody else in the history of the Iowa caucus. Who cares? As I've said on the recent hot takes that I've done in this area, the founding fathers and the framers of these various provisions anticipated that an insurrectionist and somebody that rebelled against the Constitution may also be popular. We can come back. We come back off that. We come back to the podcast host. All right, there we go. He can also be popular. And that doesn't mean he has any more right to return to office or to avoid a criminal indictment than anybody else. And I'll leave this sort of passage with this ringing, I think, of all the pages of the 57 pages, the one that will live on, I think, the most and really sums up their position is on page 40 and 41 of their decision, where they say at bottom, we cannot accept former President Trump's claim that a president has unbounded authority to commit crimes that would neutralize the most fundamental check on executive power, the recognition and implementation of election results. Nor can we sanction his apparent contention that the executive, the presidency, has carte blanche to violate the rights of individual citizens to vote. At bottom, former President Trump's stance would collapse our system of separated powers by placing the president beyond the reach of all three branches. Presidential immunity against federal indictment would mean that as to the president, the Congress could not legislate, the executive could not prosecute, that's the Department of Justice, and the judiciary could not review. We cannot accept that the office of the presidency places its former occupants above the law for all time thereafter. Careful evaluation of these concerns leads us to conclude that there is no functional justification for immunizing former presidents from federal prosecution in general, or for immunizing former President Trump from the specific charges in the indictment. In so holding, we act not in derogation of the separation of powers, but to maintain their proper balance. That is, for me, the heart, the gravamen of the decision. And I think it's 50-50 to just round out the point that you made. We talked about at the top that Chief Justice Roberts throws. I think he will throw it over and see if he can get 4 votes. See if there are 4 votes in order to take this case up on an emergency cert petition. I'm not sure that's a foregone conclusion. Now, people might be saying, well, there's 6 right-wingers. That's true, but I'm not sure John Roberts is going to join with that if he thinks that this is intellectually satisfying, this 57-page decision by the third. And if he peels away, now they've only got 5 votes. And if he can drag Gorsuch or Kavanaugh with him, I don't think Amy Coney Barrett goes, but if he can drag Gorsuch and or Kavanaugh with him, and I think the most likely person, given his prior positions, is Kavanaugh. If he can peel off Kavanaugh, they don't have the votes to bring it up for an emergency appeal. And even if they do, then it would go on a relatively fast track. We'll see an administrative stay by Justice Roberts. We'll know right away, just for a short period of time to keep the trial on ice while they figure out what they're doing at the appellate level. Then if they have the 4 votes, they'll ask for full briefing, but expedited. That would take us through the month of February into the beginning of March with an oral argument likely, New York is responding, sometime in the beginning of March with a ruling thereafter. If that ruling comes out in April or May, which is what we would expect, that's plenty of time for Judge Chutkan to schedule this trial for June or July. Now, let's say that all happens and Judge Chutkan has already indicated she's ready to cancel her vacation and do the nation's bidding and try that case in June or July. If that is what is going on, let me ask you a question as being formally in that office. There's going to be a hearing on February 15th in front of Judge Merchan. to decide what is the trial schedule going to be. We keep saying it's the end of March, but it's really not until he sets it. He now has these data points: oral argument, the appeal from the D.C. Court of Appeals. We'll know by the 12th, 3 days earlier, or 13th, whether Donald Trump is going to appeal. We think he's going to. We may not have yet John Roberts, where the full 9 members of the Supreme Court justices making their ruling yet. But if she's going to try that case potentially in June or July, what do you think Merchan does? He tries to slide Stormy Daniels and the trial against Donald Trump in the middle?
Certainly can. I mean, if I were him, because they don't have a trial date set, everything is just a guess at this point. Anything could happen. So I wouldn't give up that trial date if I were him. I think he keeps the March 24th trial date. He sets it. Everyone gets ready for trial. And if Chutkan sets another date, maybe let's say somehow they deny cert, and let's say she set a date for April 15th or something like that, he might see that date and say, okay, we're going to defer to that case and step aside, and we'll go after that case. But if there's no trial date set, there's no way he's going to let this date slip, in my opinion. And if he thinks he can get it in ahead of time, I think that's what he does. Okay,
we'll see. And we'll see if we know they're going to talk, because there was reporting that Judge Chutkan and Judge Merchan, which they're allowed to do under the judicial canons of ethics because they have the same defendant in front of them in a criminal system, even though they're in state and federal, did talk. And they'll talk again about, I'm sure the Merchan will be deferential to Judge Chutkan, who has the bigger, badder case, as I like to joke on Legal AF. And the one that is, yes, we'd like any criminal conviction, but I mean, if we had to pick one, it would be the DC election interference case, which is really trying him for all the things that he needs to be tried for about the insurrection, and have that go for. He might say, all right, well, what do you think? He says, well, I think I'm going to be able to get this thing slid in June and July, and I don't want you taking my March and having him be exhausted and not done. And then I got an argument that they can't start in June or July because they're still on trial with you. So we'll see. I think you and I need to carefully monitor with our own context about what's going to happen. We'll know more on February 15th, and we'll report on it. Well, there is an example of what we do twice a week on Legal AF. Yes, the title is exactly what you think. Lawyers who know what they're talking about at the intersection of law and politics. How novel. If you like that, you're going to love our show. I do it on Wednesdays with Karen Friedman Agnifilo, Saturdays with Ben Meisalas. And then you can pick it up on audio podcast platforms of your choice. If you know all about us, thank you from the bottom of our pod as being part of our audience. If you have, I was going to say before I move on to those who don't know us, take that clip as a gateway podlet, a little bit of an entree. Send it to your friends, family, and people in your life and say, hey, you know that show, Legal AF, I tell you all about? Here is a little teaser, a little taste. See if you like it. And if you do, join us for the full-length podcast. If you have no idea what I'm talking about, that was Legal AF. I'm Michael Popok, and we invite you to join us on Wednesdays and Saturdays at 8 p.m. Eastern Time and on audio podcast platforms of your choice. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Love this video? Make sure you stay up to date on the latest breaking news and all things Midas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.